So we have been talking about different kinds of jurisdictions still, and among the various kinds of powers that Supreme Court has, let us try to understand what is judicial review. Okay, so what is this judicial review? See, always don't get confused with judicial review and revisory jurisdiction. These both are different. So revisory jurisdiction is the power with the Supreme Court where it can correct its own judgments. Whenever there is a technical error or something else, then the Supreme Court will correct its own judgments. But what is judicial review then? The Supreme Court is the interpreter of the Constitution and its decision is final. So here the Supreme Court, which is the apex court in the country, it is also the final interpreter of the Constitution, right? It can interpret and understand the provisions of the Constitution more than any other agency in this country. So it can understand Constitution in a more best manner when you compare with all the other agencies or bodies in this country. And decisions on interpretation and giving judgments, the final authority to do that is the Supreme Court again. Understood? So the Supreme Court is the final interpreter of the Constitution. That means whatever the provisions are there in the Constitution, they can be best understood and explained or interpreted by the judges of Supreme Court, as well as the decisions on such interpretations is also the final authority to give decisions on such interpretations on Constitution is also the Supreme Court. It has the power to review laws passed by union or state legislatures. So Supreme Court also possesses certain powers to review the laws passed by union or state legislatures. See, legislature is a body which makes laws. So here, whenever the union, that means central, or the state's legislature, that means state government, whenever they make laws, take either central government or state governments. So the legislative bodies of central and state governments generally they make laws, and what these laws will be passed in their respective assemblies or the parliament, right? So when they make the laws, the Supreme Court has the power to review those laws. So why do you think Supreme Court will review the laws? Because we'll see that why it will go for a review. Review means it will just go through the law. The Supreme Court can declare a law ultra vires or null and void. So here the Supreme Court can declare a law, whichever law is made by central government or state government. The Supreme Court can declare it as ultra vires. What do you mean by ultra vires? That means that state government or central government has gone beyond its function, beyond its limits in functioning. That is called ultra vires. So null and void means it is not valid. So whenever a particular state government or central government makes a law, and when it comes under the review of Supreme Court, that particular law, what power does Supreme Court has on that particular law? It can declare that law ultra vires. That means that that particular state government has crossed its functionality or limits and it has made that law. It can declare that that particular law is made by particular government beyond its functionality, beyond its limits. It can declare like that. Or it can also declare that law as null and void. That means it is not valid. If it is against the letter and spirit of the Constitution, or contravenes any provisions of the Constitution. So when do you think Supreme Court will declare such law as ultra vires or null and void? When that particular law is against the constitutional provisions. Understood? I mean, even the spirit of the Constitution, the theme of the Constitution. These laws should always go by the letter and spirit of Constitution, whatever the Constitution is saying, whatever is the goal of the Constitution. So they should go in such a way. And if they are going against these wishes of the Constitution, then it can declare such law as ultra vires or null and void. Or if it contravenes any provisions of the Constitution, that means it is going against the provisions of the Constitution. This power of Supreme Court is referred as the power of judicial review. So review, that means going through the laws made by state and central legislatures. If they are made against the provisions of Constitution, then the power of Supreme Court to go through such law is referred as judicial review. And the Supreme Court has the power to review all national and state laws and executive orders and declare them as null and void if they go against the provisions of the Constitution. So it can declare null and void, that means invalid, and it can declare all such state and national laws. So national law means here whatever laws made by parliament, state law means any law made by a particular state's assembly or legislature. So if, or any executive order also. And remember, the Supreme Court has this judicial review power when they try to, you know, if suppose any executive authority makes gives an order which goes against the spirit of Constitution, then it can also be stopped by the Supreme Court. So the Supreme Court's power to overturn any law that it decides is in conflict with Constitution is called judicial review. So don't confuse with revisory jurisdiction where it corrects its own laws. Where it corrects its own judgments. Judicial review, it is to correct the legislative bodies of central and state governments when they make some errors or when they go against the law. See, this judicial review is used by Supreme Court whenever if any person, if they take this issue of laws against Constitution to the court's notice, then they will be doing this kind of process. So if any person takes notice of such a law to the courts, uh, suppose if they take the notice of the court, then the Supreme Court will definitely look into through its judicial review power and correct that laws, or it may ask to completely stop implementing that particular law. So this is called the judicial review of the Supreme Court of India. So here another thing is called court of record. The Supreme Court is referred as court of record. See, the word record itself says that it is having importance of the Supreme Court is getting recorded with judgments that it has passed. Okay, so the judgments passed by Supreme Court are they serve as references, hence they have to be stored, they have to be recorded and stored. So you can see this in the picture. Now all the judgments have been recorded and they have been stored like this. So the Supreme Court is a court of record whose proceedings, acts and decisions are kept in record for presentation as evidence. So the Supreme Court's proceedings, that means the way they function, and acts and decisions, that means mostly its judgments. All these proceedings and acts and judgment decisions are kept in record. So they are filed and they are stored like this for presentation as evidence. So for what purpose they have been stored like this in the form of record? to serve as evidence when need be in support of what the law is. So these records basically they are stored as evidences, and because how they have done the case, how they have interpreted the law, how they have understood the provisions of the constitution, or how they have understood that particular case, it must be evident. Otherwise, who knows what they have done? So it must have some evidence. It should be stored as evidence, and these records can be used as evidence and cannot be questioned for their authenticity in any court of India. So, see, the purpose is mainly to store them as evidence. Also, these court of record will help the other courts to go through when similar kind of cases or similar kind of proceedings when they have to make. If a high court gets a similar kind of case or proceeding that it has to make, then it will look at this case. It can take this file out of the record and it can just go through that record, how Supreme Court has done that particular case. Understood? So they can be used as evidences for the other courts to just go through and refer them. So, and these particular, and nobody can question on this kind of records, why it has been why it has been done like this, why can't it be do, I mean it can be do like, there's no such question at all. Nobody can question that kind of things in any court of law in India. The court of law is just a stored evidence which other courts also can use, and they can also pass similar kind of judgments, but not no they can take out this as evidences and again file the cases, refile the cases and all. No, it is not possible. So court of record is useful for that kind of purposes. So what do you mean? So in last previous class we have studied that these the Supreme Court generally what it does is it tries to protect the fundamental rights of citizens by issuing special orders called writs, right? So by issuing special orders called writs, the Supreme Court can safeguard the fundamental rights of people. What are the fundamental rights of people? Like, right to freedom, right against untouchability, right to freedom of speech, right to religious freedom. Many such fundamental rights are there. And in protection of that fundamental rights, it issues certain writs called habeas corpus, mandamus, certiorari, prohibition, quo warranto. So I repeat, habeas corpus, mandamus, certiorari, prohibition, and quo warranto. These are all the writs. What are these writs? These are the special orders given by Supreme Court. Now let us see what does this writs do individually, how these writs protect the fundamental rights. Let us consider the writ of habeas corpus. Anybody who files the writ of habeas corpus in Supreme Court, they get an order called you may have the body. What do you mean by habeas corpus in Latin? You may have the physical body. That means this physical body might be under someone's control. Somebody might have taken control of a person. Suppose you take person A and person B. If A has forcibly taken this B physically into control, the physical body of the person is under the control of A, then Supreme Court will ask the person A to release B. Okay, and that is the purpose of this habeas corpus. Release a person who has been detained unlawfully, whether in prison or in private custody. If this B has been taken by police, unlawfully and kept him in prison, it is, his physical body kept in prison, right? So it is unlawful. So through habeas corpus, Supreme Court may order that person to get released. Or if any private agencies or private people, if they physically detain a person unlawfully, then Supreme Court issue orders to release that person physically. So such kind of writ or order issued by Supreme Court to release a person physically is called habeas corpus, and the other writ is called mandamus. Mandamus means we command or we order to secure the performance of public duties by lower court, tribunal or public authority. So generally this mandamus writ is issued for a lower court by higher court. Especially Supreme Court will issue these orders to its lower court called high courts. For what purpose this order will be issued? To perform its duties. If any lower court or any public authority or a government authority or a tribunal, which is a special court for a special purpose, if any court or a tribunal or a public authority, if they are not doing their duties properly, then through mandamus, the Supreme Court will order that particular court, that particular tribunal, and that particular public authority to do their duty. Okay, they have to do their duties and they have to protect the public. Then comes the other writ called certiorari writ, writ of certiorari, which means to be certified. So that means under certiorari, it quashes the order already passed by an inferior court, tribunal, or quasi-judicial authority. See here, under certiorari, what the court will do, Supreme Court, it quashes the order. That means it cancels the order passed by an inferior court. That means any lower court in India, if it passed a judge and if it passed an order or a judgment, then through this writ of certiorari, it can cancel that order. Okay, so accordingly, it protects the fundamental right of citizen, because through that particular order, a person's fundamental right may be getting affected, and the court will go through that judgment passed by lower court or a tribunal or any authority, and it will ask that particular court, and it can directly cancel that order. Okay, so such is the power of writ of certiorari. And if you come, next comes the writ of prohibition. So to stop, the mandamus is issued to the lower court by higher court. Certiorari, it is also issued. It is also an order issued by higher court to lower court. Coming to writ of prohibition, to prohibit an inferior court from continuing the proceedings in a particular case where it has no jurisdiction. There is a very thin difference between writ of certiorari and prohibition. In writ of certiorari, order is issued by higher court to lower court. But here the higher court is asking lower court, the higher court cancels the orders issued by lower court. Remember, it is completely removing, it is completely asking the orders, it is asking the judgments to be cancelled, cancel the judgment, cancel the orders issued by particular court is done by higher court to lower court. Whereas in prohibition, when the case is going on in a lower court, and if the writ of prohibition is issued, then the lower court should stop dealing that particular case, because writ of prohibition makes the court consider that that particular case which is being now run in the lower court is not to be taken in that court. That means the lower court is dealing a case which is not in its jurisdiction. So in such cases, writ of prohibition will be issued, and the case in hearing stage itself is stopped. Here judgment is cancelled. Here in hearing stage itself, the case has been stopped by Supreme Court. So that is a minor difference between writ of certiorari and writ of prohibition. And what is quo warranto? This is another kind of thing. So what is your authority? It means that what is your authority? It means it questions, the court questions. to restrain a person from holding a public office which is not entitled. So if any person holds a public office, that means if he is if he goes and occupies a public office as a public authority, as a government authority, without any proper qualification or eligibility, then quo warranto writ will be issued by Supreme Court. And when such writ is issued, it, it can question the authority who is occupying that particular position. On what basis have you occupied that public office? So any public office, like any government office or any public position, if anybody is holding that position illegally, then quo warranto writ will be issued, and that particular the officer will be questioned. And if he feels, if court feels that he is holding that position illegally, then it can ask him to step down from that particular position. So these are all the kinds of writs issued by Supreme Court to protect the fundamental rights of people. So in India, Supreme Court and High Courts are empowered to issue this kind of writs. The subordinate courts are not empowered to issue writs as of now. Earlier there was such provision, but it was removed, and now only High Courts and Supreme Court are empowered to issue writs in India. So this is about the functions, about the details of Supreme Court and its other jurisdiction and other things.